Yes.
Lord, may I mention one application?
Be granted to me, Milord, to file this mandamus appeal on the
No.
basis of the server copy.
Lord, may I mention one application for recalling of a losses order, because your losses on the 17th of April, your losses were pleased to close the application for addition of party. That application of addition of party filed by my client in terms of the leave granted by the Honorable Supreme Court.
Okay.
But your lordship was pleased to close that application.
You give that.
Your lordship, I pray, my lord, may it appear on Monday, because the learned counsel from outside the state has been engaged for appearing in there.
Yes.
Lord, may I have your lordship's kind leave to mention, my lord, one mandamus appeal, my lord, arising out of a group 9 writ petition, my lord. My lord, it's an extremely urgent matter, my lord. My lord, the petitioner is under a serious threat that, my lord, his high value performance guarantee will be invoked, my lord.
Same pair,
So, lordship
for
kindly,
application.
if you lordship kindly take this matter, fresh matter, my lord, tomorrow, my lord, if it is possible tomorrow, my lord.
My lord, may I be
I'm great.
The same pair, paying for application is 872. I have notice to the other side. We are suffering banning order. They preferred an appeal.
You give it.
Mild.
My lord, may I be allowed to, my lord, file the intra-court appeal, my lord, against the server copy, my lord? I'm grateful.
This is a 2016 matter. This is a public interest litigation. The matter is the respondent, private respondent, is trying to fill up the pond. Earlier occasion, this matter was came up for hearing, and there is a stay. Despite of this order of the honorable, the matter is still pending. They are now trying to fill up the
No,
pond.
then you file a contempt petition. We list
Because, my lord, new notification has come by the state of West Bengal that clear up the pond. My lord, kindly taken up this matter, my lord.
Then, if suppose
This matter is still pending, my lord.
some subsequent developments have happened, you file a supplementary affidavit.
Yes, my lord. I shall file, my lord. Kindly, my lord. If, my lord, this matter was not taken up, my lord, then, my lord, the problem. I have served a notice.
No, you need to bring on record the subsequent developments.
Yes, my
serve the other side and then mention.
But I have also given a notice that I should.
Sir, if suppose you want, it's a 2016 matter. There is some notification. You want to bring that notification on record. You want some additional order. You file an application in the same writ petition. File the application and mention. We list the application.
Obliged to me.
Yes.
Lordship, liberty to mention this matter as a non-party appellant to file an application for leave and filing memo of appeal without certified copy.
Yes, leave granted.
Gratefully, Lordship.
My lord, may I, with your lordship's kind leave, mention a matter, my lord? This is a revenue matter, my lord, and my lord, let it be listed. I will only pray for leave to file a supplementary affidavit, because after filing this appeal, my lord, certain documents have been provided to us, which is very.
No, you want to file a supplementary affidavit?
Yes, but yes, my lord, but it cannot come unless the file comes before your lordship. So let it come tomorrow, my lord. I will pray then for leave to file a supplementary affidavit.
You give the letter. Let us see.
Yes, ma'am.
Yes, please call it.
Appellate site, daily list, serial number 1.
Yes, my lord. In this matter, I am appearing for the petitioner. Your lordship, after transfer this matter only one day heard by the then Chief Justice, the earlier Chief Justice.
What is the matter?
Your lordship, see the matter relating to the illegal fisheries. I mean, in Bengali colloquial, I mean, my lord Justice Bhattacharya knows is very in the Sandeshkhali area, and every time creating before long time, it is evident from the records. And your lordships kindly see the last order.
Initially, my lord, 32 application was filed before the Supreme Court. Your lordship was seen.
10 January 2023. My Lord Justice, the Honorable Justice, Chief Justice Prakash Srivastava and the Honorable Justice.
It alleges a very serious problem, my lord.
Passed this order.
6th January.
10th January.
10 January 2023.
It alleges, my lord.
No evidence. No affidavit has been, no report has been submitted. And how no report has been submitted, and I did not receive any copy. How I shall file the affidavit? In the meantime, what happened, my lord? The urgency occur is that in the meantime they open the lockout, and the question of 1,000 families involved regarding the 1,500 bighas of land, agricultural land, total agricultural land. They opening the lock gate from Raibangal legal river, send the salty water, I think saline water, for creating the illegal fisheries. Therefore, they are due to this salty water, unable to cultivate regarding 1,500 bigas, and the livelihood, only livelihood involved of 1,000 families of adjacent area. Therefore, Your Lordship kindly pass the order as early as possible, immediately, today, to restrain them. No report has been submitted
Yeah, it reported.
after the order 10th January 2023.
Reported
the
copy
early-
neven na pore neven.
So, Your Lordship, I have filed one application for injunction also. Your Lordship, in the Supreme Court process is this, the separate application should be filed. And Your Lordship, see the page 65. Page 65.
May I?
Page 65 to 71. And turn to the page 3 and 4, paragraph 3 and 4. Page 67 and 69.
Lord, may I?
After finish.
अरे आपका ओके बोले ओके फिनिश.
Paragraph 3 and 4. This is the vital paragraph.
এটা খোল.
There's an allegation
My lord, I have brought the photograph also. If you
that they are
want to
cutting
see.
the embankment. How you can,
May I?
show, yes.
May I? Lord, this is a very serious problem. Lord, I will not say allegation. It's a very serious problem we are facing. Lord, may I hand up the report and demonstrate before Lordship? Lord,
You give a copy to the.
the copy.
Copy has been served earlier. The order for file
He's given you,
think-
give it to.
1 week.
Lord, initially, my lord, we have, my lord will kindly see.
Just now I have received.
Daran nahi baat.
Yes.
Lord, paragraph.
We have also received.
There is a order. You will see in the
And I have
order
seen,
dated
my
10
lord.
January, just a minute, 10 January 2023. If thereafter exception in the report, if any, be filed within 1 week, affidavit.
Let us go
I
through.
I have to first, I have to see the affidavit.
Let us,
Then all right.
read. You also read.
Now, at present, I
You
have
read now, sir. We are also reading. Let us read. We'll adjourn the matter. Now, this report is of the date 15th February,
Lord,
and you have said to have floated a tender on 24th January.
Lord,
Now, what happened?
Lord, we have secured these two embankments, my lord. We have secured it, my lord. We have repaired it. But, my lord, I am told it is a never-ending process. In the sense, my lord, attempts have been regularly made to cut on different embankments. And we are always striving to save those embankments. Lord, allegation as on today,
But allegation on whatever has been made has been admitted in the report.
Lord, I must,
Has been admitted. in
I
the-
must acknowledge the problem before your lordship. my lord.
But how, some permanent solution you should suggest?
We have to increase our vigil.
Hmm.
Otherwise, my lord, this is some of the villages are benefiting from pisciculture. So they want the saline water to be drawn to their land. Some they want, some do not, like the petitioner, they do not want it. Like, we have to increase our vigil, my lord. Nothing more, my lord. We
No, if the lands are meant for agricultural land
cannot be
and
changed.
are not to be used for physiculture, then
Absolutely.
you cannot.
Absolutely, my lord.
nobody will be
That
able
is the
to-
reason, my lord, we are not allowing it. But whenever the offenses are being committed, my lord, we are lodging appropriate criminal cases as well as we are repairing the embankments, my lord. We can increase our vigil and ensure that if and whenever,
What is the distance of the embankment?
no, it's huge. My lord, I was, my lord,
Several kilometers.
I was trying to show the pictures to your
Lands of
lordship.
agricultural and
Like,
adjacent area, my lord. There
it's
is
a-
so your lordship directed to submit the report also submitted. I have to file the affidavit if your lordship give me a permit to time.
Yes.
And by calling my clients, what happened in the area. Now they have started to block my land by sending salty water with the connivance of the authorities concerned. Some authorities concerned.
All
Then
right.
it's
Your
not-
lordship see the
Now you file your affidavit.
in the meantime, your lordship passed the order not to send any saline water to my agricultural land. Then your lordship is a wide power, ample power under Article 226 in the PIL bench to start a case in accordance with the law to direct the
They are
police
also
authorities.
They are also admitting that
Yes, they are-
illegal cutting is going on.
Yes, my lord.
But what they say is the magnitude of the problem is like 24 hours vigil for several kilometers. How to?
Absolutely.
That is the
Well,
border area, just nearby Bangladesh. So they have a jurisdiction, they have a power to monitor.
Now
Your
you.
lordship also monitor this case
That's
as because the Honorable Chief Justice, the Honorable Chief Justice of EU Lolit and JB Paddiala
Oh,
had a prolonged hearing, then passed this order, send the matter
All right.
to look into the matter
Now
by monitoring the
you file your exception to the report. Huh?
next week. Your lordship.
Pursuant to the order passed by this court on 10th January 2023. A report in the form of an affidavit has been filed by the executive engineer, Basirhat Irrigation Division, village Dali Itta, district North 24 Parganas. On a reading of the affidavit, it is seen that substantial part of the allegations made by the writ petitioner has been admitted, in as much as there has been cutting of the embankment of the river by certain miscreants with a view to draw saline water to their lands for the purpose of pisciculture. It is admitted in the report that several such instances have been found, and whenever it is found, criminal cases have been registered against the offenders, and simultaneously steps have been taken by the department to repair the river embankments. One such exercise has been conducted in the right embankment of river Choto Kalagachi. Is it? Choto Kalagachi, and right embankment of river Baro Kalagachi for a length of 20 meters into 20 meters and 3 meters respectively, and a tender has been floated for an amount of rupees 12,86,105.00 on 24th January 2023. The learned Mr. Chatterjee learned government council submitted that the work has been completed and the embankment which was illegally cut has been repaired and restored to its original position. The respondents would admit that the problem is a perennial problem, and considering the vast stretch of the embankment, the officials are endeavoring their best to keep strict vigil so that the miscreants do not in any manner cut or damage the river embankments. Full stop. The learned advocate appearing for the writ petitioner prays for time to file an exception to the report submitted by the executive engineer. Full stop. Let such exception be filed within 2 weeks from date, 3 weeks,
2 weeks.
2 weeks, 2 weeks from date.
In the meantime, my lords.
In the meantime, the respondent authorities are directed to strictly monitor the area and prevent any miscreants from cutting the river embankment. Regular patrolling may be done in the area, and the local panchayat shall issue public notice to all the landowners in the area that if any person attempts or cuts the river embankment, deterrent action will be taken against such of those persons. This should be given wide publicity in the area, and the people should be sensitized that if they violate the orders, they will be penalized. Let the matter appear on so and so date. Give a date.
29th June.
No, before, my lord, before. My Supreme Court will be start on 3rd. Therefore, end of the
After 2 weeks means when it will come?
10 days, after 10 days. After
You have requested for 2 weeks. So let it come on 29th.
27th.
Exactly 2 weeks hence.
27th, he will see. If he will see.
Lord, Panchayat is not a party. Lord, Panchayat may be added as a party to ensure, Lord,
But which panchayat will add?
that, Lord, my learned friend can.
No, sorry, please come. The district magistrate, not 24 Parganas, is directed to issue a communication to the concerned panchayats through which the rivers pass, and direct the respective pradhan of the panchayat to give wide public notice about the order passed by this court, and warning the general public that none should resort to cutting of the river embankment, and if any such attempt is made, strict action will be taken.
I remain grateful, Lord.
Next.
Serial number 2.
I'm grateful.
But to appear for the appellant WBSC DCL, well, our instruction is not to proceed with the appeal. Written instruction.
You have written instructions.
Yes.
The learned advocate appearing for the appellant has produced a copy of the written instructions given by the appellant dated 29/5/2023, stating that the appellant seeks to withdraw this appeal. They said letter is taken on record and the appeal is dismissed as withdrawn.
Deeply grateful, Lord.
Serial number 3.
This has come up. This matter has come at my instance, my lord, for mistake in the order. My lord, what had happened in this matter, my lord, my tender for road transportation was rejected by the Hindustan Petroleum.
So, invoke the
Lord, I am
arbitration.
appearing on behalf of the
Observations
respondent in
made
this
by the
matter.
learned single bench and observation made in the judgment should not affect the rights of the appellant.
My lord, this was not my submission. My lord, your lordship, after passing the order, my lord, I had just inquired because your lordship has said that it is not maintainable, you should go for arbitration. So my lord, I requested the lordship that I will cite decisions after vacation regarding maintainability of writ petition. Your lordship, no, lordship, bear with me, your lordship refused. Then the lordship dismissed the order. Then I said, your lordship is not sending me to arbitration. Then your lordship passed an order that if arbitration is invoked, the findings of the division bench and the single bench shall not bind the parties. That was your lordship's my lord, direction. My lord, that has not gone down. It said,
No, it has gone down.
no, my lord, that is, you see.
Paragraph 5, you please see page 4, paragraph 5.
Paragraph 5. As we have dictated the order, the learned advocate for the appellant submitted. It is my submission, not your lordship's direction.
But your lordship has directed that.
Direction is not there.
Yes, my lord.
Your submission is recorded.
Yes, my lord,
Yes,
this is
Mr.
not my
Chatterjee, what do you
submission,
want
my
to
lord.
say?
My lord,
This is a submission, my lord, of the of the appellant, my lord. My lord, the writ petition was dismissed on merits, my lord, and all the points possible taken by the respondents were adjudicated upon, and they were given ample opportunity has been heard, my lord. My lord, after the appeal has been dismissed, lordship, after hearing of the appeal, once it's been dismissed, my learned friend can't come up and agitate these sort of issues. But these are the submissions which my learned friend is making. That's not a mandate of the court which my learned friend is trying to misinterpret at this stage. But whatever avenues are open for the appellant, they can take, they can do it. They are at liberty under the law to take avenues under the whatever is there.
In case he resorts to arbitration, then it shouldn't be said that the applications in this order.
Now with the series of judgment that has come up, NG projects and all lordship is well aware of. My lord, once the read court goes into the merits, my lord, and they decides the issues involved, my lord, only with regards to if they have suffered any damages, that will be adjudicated in the arbitration. But those judgments of the full bench of the Honorable Supreme Court is very clear.
Your lordship, see, your lordship had passed the order. I'm not saying your lordship had not passed the order. Your lordship will pass a new order. Your lordship will consult the stenographer also.
No, we have signed the order and it has been uploaded. Suppose you want the order to be modified, you will have to file a review application.
This is my observation, my lord. I had not made any submission. That has been wrongly recorded. Your lordship will delete that.
No, I join issue here, my lord. It was a submission of my learned friend, my lord, which has been recorded in the order, my lord.
Regarding review
Listed under the caption to be mentioned. It is submitted by the learned advocate for the appellant that the submissions made by the learned advocate as recorded in paragraph 5 of the order dated 18/5/2023 may be deleted. In the light of the said submission, paragraph 5 of the order dated 18/5/2023 stands deleted, and the necessary modification be made in the order dated 18/5/2023, and this order shall form part of the order dated 18/5/2023. In all other respects,
and leave be given to file a review application. That permission leave to be given. That your lordship will kindly, my lord. Otherwise, my lord,
in all other respects,
my lord, your lordship has passed the order.
Will stand. Next.
Serial number 4.
Grateful, my lord.
Yes.
I'm for the appellant, my lord.
Yes.
Led by Mr. Anirban Ray.
The IP for the writ petition has responded.
Yes.
May I file the affidavit of service?
But unless my learned friend has any objection, but I would like to come up with an opposition within a week to the stay application. Because we were all along enjoying an interim order, and finally, my lord, we have succeeded in the writ petition. There was no application for vacating also before the writ court. And my lord, the court has recorded that the appellant over here will not file affidavit in opposition in the writ petition also. So kindly permit me a week's time to come back, my lord, after filing.
My lord, it is their writ petition. They had argued this matter on their writ petition.
No, what is the
My lord, what is the scope of filing now, my lord, an affidavit?
No, the respondent DVC shall evaluate the technical bit of the petitioner and allow the petitioner to participate in the tender.
My lord, I'm late.
Yes, please.
My lord, my lord,
yes.
May I just make one submission? My lord, here, my lord, a tender had been challenged. Now, my lord, the writ petition proceeded on the writ petition itself, because we did not file any affidavit, my lord. So, my lord, I really don't think there is any scope of any affidavits. I'm sorry.
Okay.
Because, my lord, my learned friend cannot increase on the scope of the writ petition. So that is why I'm submitting, because, my lord, this is a tender where, my lord, and your lordship knows ash ponds, my lord,
ash ponds are
But
filling up.
in that case, my learned friend will not rely upon the documents which he has annexed with the stay application and was not part of the proceedings before the learned.
But I have only done that, my lord. May I just point out, my lord? I have only done that to seek, my lord. I know your lordship takes up the appeal and disposes it of. Because of the stay, my lord, I had to show my urgency. Because it's an ash pond, it's filling up, my lord. In today, my lord, it generates electricity. Your lordship has seen even yesterday, my lord, that there has been complete power failure. And your lordship knows if I cannot do away with the fillings of the ash pond, my lord, then the plant will come to a standstill completely.
Now, what was the reason for rejecting that?
Yes, but I'll give a short, my lord, background, my lord. My lord, this is a second round of litigation on a scope of, my lord, interpretation of the terms of the same tender. My lord, the tender, my lord, requires an integrity pact to be signed by my learned friend's client and all prospective bidders, my lord. The integrity pact, my lord, requires that there are two sections, my lord. I'm just giving a very short background, then take your lordship. My lord, the integrity pact requires that there should not be any transgression of any law, especially, my lord, it relates to the Indian Penal Code and, my lord, the Prevention of Corruption Act. And also says that if there is any apprehension on the part of the tendering authority in any form, then also, my lord, the tendering authority can refuse to accept the bid. And, my lord, there is another clause, my lord, which is clause 5. My lord, this is clause 3 and clause 5, my lord, which says that this transgression with regard to any other company outside the country or any other public service enterprise, if within 3 years, then they have to show that. Disclose. So one part is with regard to companies outside India and other enterprises, and 3 is with regard to me. Now, my lord, we found, and it is an established, there's nothing wrong about that. It is a pointed out, my lord, there was a FIR which was lodged in respect of a similar job which my learned friend's client was doing with me in 2018. Now, my lord, this ultimately, my lord, ended up in a charge sheet in 2019. Now, my lord, the question was, we said that this falls within section 3. Now, my learned friend's client had gone up from that, my lord, letter, that earlier letter, my lord, had gone up in an arbitration where my learned friends had been able to secure an award saying that there was no fraudulent practice. Yes. But the point remains, your lordship knows that's a civil dispute. My learned friends cannot say that the arbitrator could pass a order of under the IPC saying that this criminal proceeding cannot continue.
No, he can't quash the FIR.
He cannot. Now that FIR and charge sheet is still pending. So the question was that whether I have a reasonable apprehension to doubt the credibility of the prospective bidder, that is my learned friend's client. This was also not disclosed, my lord, that there was this charge sheet. This was also not disclosed by my learned friend's client. So ultimately, my lord, we ultimately got this and we rejected his bid. On section 3, the learned single judge, my lord, proceeds on the basis of section 5, saying that there the transgression is for 3 years. This period is beyond 3 years because FIR is of 2018. Therefore, I have wrongly invoked section 3 because section 3 is also to be read as 3 years. This was one. And, my lord, the similar terms had been, my lord, a similar order was passed by the learned single judge, which came up before the division bench, before this honorable court, where such order was, again, my lord, set aside. And there was an interpretation that this time period was within the 3 years, and otherwise also, my lord, under the laws of tender, my lord, your lordship knows better than me, it has become very strict now. After NG projects, and my lord, there's a very recent judgment also saying that even if I wrongly arbitrarily reject his bid, then also he has no rights. You have to go up in a civil suit. That is the law of the land now. Be that as it may, Malad, from that order, the earlier order, Malad, if I may be in a position to explain, Malad, my learned friends had gone up to the Supreme Court. Now, when my learned friends had gone up to the Supreme Court, the single judge was of the view that because the division bench judgment, when I showed the honorable single judge the division bench judgment, it's a precedent. The honorable judge was of the view that let them have some time to go and set aside that order. I did say that this is a precedent, but whatever it is, well, we waited. They have not been able to secure any stay also. And Malad, that is still pending before the Supreme Court. So today, Malad, the earlier judgment on interpretation of the same terms is a precedent and was a precedent before the single judge. But the single judge was of the view that since it is pending in the Supreme Court and she records that there is no stay, she does not take it as a precedent. So Malad, today, Malad, may I just start the matter, Malad? Malad, may I just place some relevant parts of the judgment first, and then I'll take your lordship to the clauses only, Malad.
Okay, can we see the impugned communication that is 15th,
Yes, Malad, definitely.
15th November.
Yes, yes. Please, number two. Just give me a moment. Oh, well, kindly takes page 72. Well, is your lordship with humility? 894 jeta hai. 894. Well, it kindly takes, this is the first rejection at page 72. This is an automated rejection. Well, it kindly sees, dear user, with reference to your bid submission following tender, Malad, it gives the reference. You are informed that your bid for the above tender has been rejected during technical evaluation by the duly constituted committee for the reasons administrative ground. In case of any clarification or feedback, you may contact tender inviting authority. They had contacted Malad.
They sought for reasons.
Yes.
Then where are the reasons?
And reasons are, Malad, your lordship will kindly take this should be the second volume, page 588. Is it 588, Malad.
588.
I will find the reference. Your letter dated 16th November 2022, received by the email of 16th November 2022. The reasons on which the technical evaluation committee has rejected your bid is furnished as below. Fraudulent practice was noticed against you related to pilfering of DVC's transported good quality coal and replacement of the same with some extraneous materials like boulders, mudstones, while executing a coal transportation contract of RTPS DVC. Same was proved on 1st June 2018 by RTPS officials in presence of the contractor's representative. Letter was issued to you on 2nd June 2018, intimating this incident of ill practice by them. FIR was registered on 9 June 2018 by DVC officials. The charge sheet, final report, was issued by the Raghunathpur PS District Purulia WP on 24th October 2019. You have repeatedly suppressed the above charge of pilferage and fraudulent practice. Thus, you have committed a transgression through a violation of section 3.
Now let us see section 3.
Yes, Malad. So Malad only keeps note, Malad, that our letter only relies on section 3. We did not take recourse to section 5. When it kindly comes to page, the first volume, Malad, 205.
These are the tender conditions.
Yes, ma'am. I am sure my learned friend will not, this is a part of the tender condition. So, my lord,
Page 205.
my lord, 235 is the one executed, 205 is the, my lord, it is the format. I'm sorry, my lord, you'll also kindly go to 235. Because that is what they had submitted, so. And your lordship will find section 3 at page 236.
Integrity pact.
Integrity pact, my lord. And may I just place it if you lordship?
Yes.
236, my lord, section 3. Disqualification from tender process and exclusion from future contracts. If the bidders, contractors before award or during execution has committed a transgression or violation of section 2 above. Now, my lord, kindly sees or in any other form such as to put his reliability or credibility in question, the principal is entitled to disqualify such bidder, contractor from the tender process or to terminate the contract if already signed and to take action as per the procedure of banning of business dealings of the principal.
Now, which would be the relevant clauses in section 2?
My lord, no, my lord, may I just say this, my lord? I am relying on the second part. And that's why, may I just read it again? If
Or
the
in
bidders,
any other-
if the bidders, contractors before award or during execution has committed a transgression through a violation of section 2 above, or in any other form such as to put his reliability or credibility in question. Not only under section 2, my lord. Any other, because it is for me, my lord, kindly let us be very candid, my lord. It might be a very crude example. My lord, let us say, my lord, I have someone employed in my house for some job, and he has carried out something or done something which, according to me, let us say it was a theft. I am the tendering authority. If I feel that this person is not credible, and my lord, he has suppressed this, he has not disclosed this of the charge sheet, and I find that there is a charge sheet against him in respect of a FIR which I had only made, my lord, will I be entitled to disqualify him or not? Would that tantamount to an action which is arbitrary, malafide? Because these are the only 2 points, my lord. My lord, if there was nothing of this sort and I had resorted to this, yes, I would say it's arbitrary. With humanity, I submit, obviously, subject to what falls from your lordships. My lord, single judge holds that yes, there's a transgression, but it is post 3 years. And she relies on, my lord, section.
No, according to you, the transgression has yet to attain finality. Charge sheet has been filed.
Yes, so that creates the.
So, say, according to you, section 5 will not be attracted.
No, my lord, may I just place section 5 once?
Yes, 237.
Yes, my lord, kindly see.
Yes, that no previous transgression
That
occurred.
now, my lord, kindly see, there's a small difference, my lord. Here the bidder declares.
Correct.
The bidder declares that no previous transgressions occurred in the last 3 years with any other company. When it says any other company.
Any other company.
In any country conforming to the anti-corruption approach or with any public sector enterprise in India that could justify his exclusion from the tender process.
Yes.
My lord, when it says any other company, my lord, obviously it's an exclusion. Then kindly sees the same clause is there. If the bidder makes incorrect statement on this subject, he can be disqualified from the tender process or action can be taken as per procedure of banning of business of the principal. Now, my lord,
on this subject would be subject.
Or the first one, my lord.
First point.
That is non-declaration of transgression with any other company in any other country within last 3 years. So, my lord, that last 3 years, my lord, the single judge, my lord, was of the view, since this is of 3 years, this should be imported into section 3. Now, my lord, may I, with humility, I submit, my lord, your lordships have set the rule. The interpretation lies with the tendering authority, unless it is not a plausible my lord, interpretation. So the question is, because your lordships have themselves, your lordships have already held so many precedents, my lord, that the courts will not interfere in tender matters.
That's on the law. Let us be. Now let us see the division bench judgment, where you, according to you, interpreted section 3 and 5.
Yes, well. My learned which will also be having minute, because this was valid in the other matter, minute. May I just point out one? Mallet kindly sees page 2, Mallet.
Yes.
Mallet, may I just also say this, Mallet, again with humility, Mallet. The single judge is also, she has also, Mallet, stated that is on same facts. That has also been recorded.
That we'll go through. You
Yes,
just,
but let us also see, Mallet. Mallet, kindly,
just in
yes, Mallet, kindly see paragraph 3. The writ petitioners, BLA Projects Private Limited, and appellate number 1 integrity pact, a set of organizational procedures to ensure fairness and transparency in the tender process. Section 2 of the pact provides for the commitment of the bidders, contractors towards the principal. In order to prevent corruption, Mallet, it goes on, Mallet. Kindly then see section 3 of the pact. If your lordship has seen that, the last sentence, Mallet, for disqualification of the bidder. If the bidder has violated the provisions of section 2 or during the execution or in any other form such as to put his integrity into question. Section 5 of the integrity covers previous and restricts the requirement of declaration, which forms a part of the tender document of September 2022. Moreover, bidder is disqualified from the tender process, banned from business on the ground of incorrect declaration. Well, as if lordship got that, but page paragraph 3, madam reading. Then, Mallet, the finding, if your lordship kindly sees, kindly comes to paragraph 5, the FIR of 9 June, Mallet, just in the middle, if your lordship kindly sees, at paragraph 5. That the writ petitioner indulged in fraudulent practices which resulted in FIR being registered on 9 June 2018 and a charge sheet of 24th October 2019. It was, however, held by the learned singer that the charge of pilferage and fraudulent practice do not form part of the commitments under section 2 of the Integrity Pact. So the impudent disqualification was grounded on transgression of section 3, which in turn is confined to a violation of section 2 of the Integrity Pact. The section 3 does not refer to any past transgressions. It was further held by the learned single judge that section 5, what your lordship sees again at paragraph 6 of the Integrity Pact covers previous transgressions to 3 years preceding the Integrity Pact, which forms part of the tender document of September 2022.
You can come to para 9.
Mallet, para 9.
That's the finding.
Yes, Mallet, that is.
That's the finding. But the learned judge has proceeded because the limitations for the court to interfere in commercial transaction, you can't interpret the terms.
Yes.
On that ground, the appeal is allowed.
Yes. And he said, even Mallet, if your lordship kindly sees.
Yes, we have read para 9,
Yes,
10 and 11.
Yes.
Scope of judicial review, etc.
That has and it's the same Mallet tender condition.
Same tender condition. Now let us see the single bench order.
Yes, Mallet. Mallet, since I'm on that, Mallet, kindly sees Mallet the single bench order, Mallet. Mallet, since we are on this judgment, Mallet, if your lordship kindly takes paragraph 22 of the judge, the impugned judgment, so that we can see how this has been dealt with, and then I'll take your lordship to the other parts of the judgment. Since we are on the earlier division bench order, kindly takes, Mallet, paragraph 22 of the impugned order or judgment. It is, has your lordship. It is also the contention of DVC. The findings of division bench in its judgment pronounced on 20th of January 2023 are binding on this court, since it set aside the judgment of this court in an earlier proceeding with the same parties on similar facts. The division bench judgment was challenged by the petitioner and is now before the Supreme Court. The orders passed by the Supreme Court on various days makes it clear that the matter is under consideration. The orders show that the matter has been listed for final hearing at the admission stage and the respondents were directed to file their detailed counter affidavits. The fact that the earlier writ petition and the present petition are factually similar would also be evident from both the petitions as well as DVC relying upon the documents in the special writ petition pending before the Supreme Court. That's it. Then, my lord, we came up before your lordship, but your lordship was not minded to go in because it was the interim stage, but we preferred an appeal. That because this we had shown to the Honorable Single Judge that this was binding. Your lordship said, go back, final hearing, finish it, and then if required. So, my lord, from there we have come back with. So, the learned single judge thereafter records.
How you show us how the learned judges.
Yes, my lord. May I just take your lordship now to the
interpret section 3 and 5.
Yes, my lord. My lord, kindly takes
Para 7.
My lord. The question which is required to be answered is whether the impugned rejection of the petitioner's technical bid falls within section 3 of the Integrity Pact or any other of the relevant clauses which have been referred to by the parties in the course of hearing. The Integrity Pact is part of the tender documents circulated to the bidders and set of guidelines for governing the selection process in terms of for preserving transparency and fairness in the selection of the bidders. Section 3 relates to disqualification of bidders and the exclusion from future contracts, and section 3 has been set out. Then see paragraph 8. Section 3 contemplates a transgression, so violation of section 2 or in any other form as to cast a shadow on the reliability of the bidder. So this is the interpretation of the Honorable Single Judge also. Section 2 lays down a set of measures that to be observed by the bidders during participation in the tender process and the execution of the contract as essentially relates to commission or offense under the Indian Penal Code or the Prevention of Corruption Act 1980. Significantly, violation of section 3 of the Integrity Pact is the only section referred to in DVC's reply of 24th November 2022. The letter does not specify the violation or how the petitioner has committed transgression of sections. But with humility, I have shown the letter. It relies on that FIR, the charge sheet, and that it has been suppressed. Then section 5 of the Integrity Pact, which covers previous transgressions, assumes relevance in view of the allegation of transgression made by the DVC. Section 5 is set out below. It is important to note that the occurrence of past transgressions has been restricted to 3 years prior to the date of the tender or the date of furnishing of documents of the bidder. Section 5 therefore limits the period of transgression to a finite period. Section 5 also becomes relevant when seen against the first ground stated in DVC's letter dated 24th November 2022, which mentions fraudulent practice and privilege. The first ground, however, specifies that the alleged offense was proved on 1st June 2018 and FIR was registered on 9th June 2018, followed by a charge sheet on 24th October 2019. These dates are significant since proving of the offense on 1st June 2018 would naturally mean that the alleged offense was committed by the petitioner at least before June 28. Although the word transgression has not been defined in the Integrity Pact, even if it is assumed that the petitioner was guilty of fraudulent practice, pilferage, the said transgression falls beyond the 3-year window under section 5 of the Integrity Pact. The tender was issued by DVC on 7th September 2022. 3 years had therefore clearly passed, even if the FIR is taken as the starting point. So also significant section 5 to authorizes the principal tendering authority to disqualify a bidder from the tender process or ban the bidder from future business dealing only if the bidder makes incorrect statements on the subject of past transgressions under section 5.1. But this is contrary to section 3. With humility I submit. Because section 3 also allows this. And that is why I humbly submit 3 and 5 are different. Then one sees, although the letter of DVC dated 24th November 2022 does not mention any other section of the Integrity Pact, counsel appearing for the parties have referred to other clauses of the tender documents the court also proceeds to deal with. Then it goes under clause 2.3. Now, my lord, your lordship will kindly notice, till now, my lord, the second part of section 3 has not been dealt with by the learned single judge.
Yes.
Then, my lord, kindly sees Because in my letter, my lord, the first point was suppression of these charge sheet. Then my lord kindly sees paragraph 12. There the point was taken that it is not mandatory that that will be disqualified, but there could be mitigation steps which can be taken. But kindly may I just place it very quickly. Clause 2.3 of the policy for withholding and banning of business dealings provide for an obligation on the part of the bidder to make proactive disclosures. Clause 2.32 requires the bidder to declare previous transgressions, whether asked or not in a bid document during the last 3 years, or of being debarred by any other procuring entity. Clause 2.33 relaxes the obligation to the extent of stating the declaration of transgression made by a bidder under clause 2.32 committed under the last 3 years or debarment would not lead to automatic disqualification, but may be evaluated. But that is a discretion of the tendering authority. Then kindly sees, now the learned single judge holds, therefore clause 2.32 and 3 read together indicates that the bidder is required to disclose previous transgressions committed in the last 3 years, and further that the disclosures made would not result in automatic disqualification. Now, this is a finding which is absolutely contrary to humility submit to the wordings of section 3, and even if I take section 5, the wording is also, it is contrary to section 5.
So therefore, the learned judge reads section 3(5) and clause
2.3. Yes.
And says that
it will be 3 years.
No, first interpretation is 3 years.
Yes.
So even assuming that, it is not a ground for disqualification.
Yes. Because there is a clause which says I may not disqualify. But when it's humility,
mitigating steps maybe.
I might and I might not. And Malad, that is not a ground taken, Malad, in the writ petition also. That I have not mitigated, that is not the point. He says my rejection is bad. That was argued. So therefore, there was a counter argument from our side also. Then Malad 14 is the finding. From a conjoint reading of all these conditions, it is clear that the obligation on the part of the petitioner was to disclose past transgressions which occurred in the 3 years prior to the date of the tender and would hence not cover the alleged fraudulent activities which occurred before June 2018 with a specific case stated by DVC in the letter of 24th November 2020. The issue which emerges is whether the tender condition read with the integrity pact structured by DVC contemplates excluding of a bidder by reason of transgression under the sections of integrity pact where the transgression has taken place beyond the 3 years reckoning. The scheme of the terms and conditions make it clear that the culpability with regard to violation of any of the sections resulting in transgression must relate to a fraudulent practice which is limited to the 3 years preceding the tender. But with humility, it is adding to the language of the tender terms. The sharpness of the penalty had somewhat been blunted by clause 2.33 of the policy for withholding and banning of business dealings in the manner stated above. Hence, the argument that the petitioner committed violation of section 3 of Integrity Pact by failing to disclose the FIR and charge sheet of 2019 and hence transgress the integrity of the process is inconsistent both with the policy of banning as well as the Integrity Pact. Manad, the policy of banning was not relied upon by us, and that only gives a right to me that either I disqualify or I might mitigate. And Malad, the Integrity Pact might have shown your lordship, Malad. It gives me the right. The second part with humility has not been dealt with. Equity demands that no one can be made to suffer the consequence of offense for all time to come unless the law prescribes such. Every man has a legitimate expectation of redemption. In this context, is further significant the allegation of fraudulent practice stated in the letter of 24th November 2022 was a subject matter of an arbitration proceeding which resulted in a specific finding in favor of the petitioner, namely that the allegations were false. And the police has drawn a charge sheet. That cannot be a binding, what cannot be binding on that charge sheet, Malad? The learned arbitrator passed out on 14th August 2021 in favor of the petitioner for damages of rupees 15.41 crores. DVC is not willing to give any credence to this award on the grounds that the award has been challenged. This court is, however, of the view that the challenge cannot dilute the admitted position that the petitioner was exonerated from the allegations of pilferage and fraudulent practice, which was the state of affairs on the date of the petitioner's participation in the bid. DVC stands reflect the mindset of making the petitioner to pay for the alleged offense for all times to come. The allegation the petitioner has suppressed the fact of the FIR and charge sheet in 14 other tenders must also be read in context of sections 2, 3, and 5 of the Integrity Pact, which limits the culpability to 3 years immediately preceding the tender. The same reasoning would also apply to the allegation the petitioner had an obligation to make a frank and voluntary disclosure of the fact while participating in the tender. The law with regard to interference of a writ petition matter tender has been laid down by the Supreme Court in several decisions. Tender floated by the government must be imbued with the transparency and must not create conditions and circumstances which favor a particular bidder to the exclusion of the rest. The Supreme Court has repeatedly discouraged invoking the jurisdiction of the High Court under 226 of the Constitution of India for testing the case brought by an unsuccessful bidder. So that would amount to evaluating the terms of a tender which is best suited for the tendering authority. With humility, my lord, this is the law. But the learned single judge has gone on to interpret.
Learned single judge has rightly noted the law, but says that your action is arbitrary.
My lord, therefore, my lord, I have also relied on a judgment which says, first of all, my lord, I'm joining issues with that. Because arbitrary, my lord, would be something which, again, as I said, my lord, if there was no charge sheet, yes. Now, my lord, if it is tailor-made, my lord, my learned friends has not challenged the tender conditions.
No.
So it was not tailor-made.
He can't, they can't also.
Well, they can.
No,
if it
having participated, how
that is why, my lord, I'm saying before participation, they're not challenged. That is what I wanted to say. Because once they participate, they cannot. That is the law.
Now, can you show us that disclosure portion in the tender form, where they'll have to say about the, you said that non-disclosure, the FIR and charge. Probably their contention is beyond 3 years, I won't disclose. But let us see the condition, that form.
My lord, may I just, may I just show first, my lord, clause 2.3, my lord, I think that is. My lord, what your lordship is, sorry. For 3 years. Has to get with section 5.
Yes.
Yes. My lord, kindly, my lord, takes note of 2 things, my lord. My lord, this disclosure, my lord, I have shown that when section 3, my lord, does not talk about any declaration.
5 only talks on
5 don't talk about it. Now, my lord, it also relates to, my lord, the banning policy. So, my lord, those clauses I'm just trying to show your lordship, clause 2.3, 1, 2, and 3, my lord, that I think will, my lord, solve it. Other than that, my lord, I must also say, my lord, there were two other things, your lordship, my lord, that's been recorded in the learned single judge's order, my lord. There were 14 other tenders also. There again, it was also not disclosed. And another point, my lord, which I had always, my lord, sought to take, but, my lord, if your lordship kindly reads, my lord, the charge sheet is in 2019, October 2019. That makes it within 3 years also. My lord, FIR, my lord, with humility, my lord, it does not initiate, it initiates the investigation.
So when was the tender notification?
7th of September 2022. That's recorded, my lord, in the learned single judge's order.
So it is within 3 years.
Yes. Even if I concede to the interpretation given by the learned single judge, my lord. Because learned single judge of the view that since it is in 2018 that you have made the FIR, therefore it starts from that day.
So according to you, it's only a starting point of investigation.
Yes.
And you may close the complaint also if
it could have.
Not going.
It could have. But
No,
there it starts.
You
But
show that
yes, my lord.
disclosure. to
My
us.
lord, kindly comes to page 140. Well, this starts at page 141, policy for withholding and banning of business dealings. And the clause, your lordship, will kindly come to page 140. At page 144. Has his lordship got that, my lord?
141 is banning. At 144 is.
Yes, but before that, my lord, may I just show your lordship that here fraudulent practice has also been, my lord, defined. If your lordship kindly takes that for once at page 143, then I'll take your lordship to 144. At 143, if your lordship sees clause 2.2, my lord, if your lordship, has your lordship got that, page 143, my lord. Procuring authorities as well as bidders, suppliers, contractors, consultants, receivers, providers should observe the highest standard of ethics, should not indulge in the following prohibited practice either directly or indirectly at any stage during the procurement process or during execution of the resultant contracts. Kindly sees B, my lord, fraudulent practice, any omission or misrepresentation that may mislead or attempt to mislead so that financial or other benefits may obtain by or an obligation be avoided. This includes making false declaration or providing false information for participation in tender process or to secure a contract on execution of the contract.
To any omission, according to you.
Yes, madam. Madam, with humility. Today, my lord, if this was produced or my lord, this was brought to my notice, well, my reaction would have been I rejected him.
But admittedly, you have not resorted to this banning procedure.
No, I have not. I have not also said that I will not ban them, but I have disqualified them at this point.
Their technical bit has been disqualified.
Yes, my lord. My lord, may I just point out, because this needs to be pointed out. 894 to the final. In 894, my lord, which your lordship is going through, my lord, there was no injunction. Till there was no injunction, my lord, the final the reverse, there's a process of reverse e-auction. The final bidder was also identified.
Now, what about the other 14 people, according to you, who had omitted to?
Not 14 people, my lord. There were 14 other tenders where they have omitted that.
Oh, they have submitted 14 other
Yes,
tenders.
my lord. That was also given in an affidavit, my lord, which would also show it was from 2021, 2022.
And
so,
what they have not challenged those 14 rejections.
Sorry, my lord.
In
they were not successful. But there again, it was suppressed. That's why in my notice, in my reply, I've
those tenders, technical bid was not rejected.
No.
It was allowed to proceed. They are not successful.
They were not successful because that was not brought to our notice. Because my tendering authority and the ground, the engineer, they are different, my lord. So it was never brought to our notice. Now that it was brought to the notice, my lord, Therefore, in the reply which was given, we have said that you have repeatedly suppressed this. Which also, my lord, falls under the second part of section 3. If they were so confident, then they should have disclosed it.
Yes.
And my lord, the sections are 409, 420, 506. The charge sheet of the IPC. Now, my lord, kindly takes page 144. This is what has been looked into by the Honorable Single Judge, and my learned friend shown. I have also counted that, my lord. Kindly sees 2.3. Obligations for proactive disclosures.
Yes.
Procuring authorities, as well as bidders, suppliers, contractors, and consultants, service providers are obliged under Code of Integrity for Public Procurement to suo motu proactively declare. Suo motu proactively declare any conflict of interest coming under the definition mentioned above, pre-existing or as and as soon as these arise at any stage. In any procurement process or execution of contract, failure to do so would amount to violation of this Code of Integrity. And any bidder must declare, whether asked or not, in a bid document, any previous transgression of such a Code of Integrity with any entity in any other country during the last 3 years, or of being debarred by any other procuring entity. Failure to do so would amount to violation of this Code integrity. So, my lord, 3 years is any other entity. Then 3, to encourage voluntary disclosure. Now, this is what the learned single judge has relied upon, my lord. To encourage voluntary disclosure, such declaration would not mean automatic disqualification for the bidder making such declarations. The declared conflict of interest may be evaluated. So, my lord, if they are declared, it could have been evaluated. And mitigation steps, if possible, may be taken by the procuring authority. May be taken. Similarly, voluntary reporting of previous transgression of Code of Integrity elsewhere may be evaluated in barring cases of various grades of debarment, and alert watch may be kept on the bidder's action in the tender and subsequent contract. The learned single judge, with humility, my lord, has held that it is a mandate.
According to you, it's a discretion.
Yes, because, my lord, section 3 of the Integrity Pact, my lord, this only deals with, this is more like that is the act and this is the rule.
Correct.
So that clearly provides.
Yes.
So, my lord, this is the nutshell of the facts, my lord. Now, my lord, if you
Not nutshell, that's it.
my lord, that is the fact. I'm sorry, my lord.
Oh,
I should have said that. I'm so sorry.
It's a very short.
Subject to what Mr.
We will hear Mr. Dattu, and then
My lord, the judgments, if your lordship,
judgment you give a compilation. If you got a compilation.
and I haven't got it, I can give it by afternoon, my lord.
Already the learned judge has set down the law.
But it is, that is, yes.
The learned judge has accepted the legal position.
My lord, that very,
It says that there is a window where the court can interfere when there is arbitrage. That's settled.
my lord,
position.
may I just say this, my lord?
Court cannot interpret the terms of conditions of tender.
My lord,
Court cannot sit in the armchair of the tender inviting
my
authority
lord, I'm very grateful.
and
my lord.
decide who's best for you. It can't do. Then the court cannot add words, letters, sentences to the tender conditions.
My lord,
It cannot direct discretion to exercise discretion or direct you to exercise discretion in a particular fashion.
my lord, I'm very
All
grateful.
those things are all.
My lord,
well-
may I then, my lord, have the
Only
liberty?
one judgment you give. The
My lord,
latest.
2.
Two judgments.
Two.
are.
NG project?
In fact, that latest decision, the learned judge has referred.
NG projects, my lord.
NG project.
But I will only show that. May I just show that, my lord, if your lordship kindly permits. Shall I put on? Kindly, my lord, I'm sorry, my lord, mine's your, my lord, fingers, my lord, it's stapled, well, I'm so sorry, my lord.
No.
Should I? NG project, second down now. 2022 6 SCC 127. My lord, this judgment, my lord,
Yes.
my lord, I would be relying on paras 13, 14 17, 23, 26, 27.
Yes.
Sorry. Malad will kindly see 17. What just now fell from your lordship, but this is what is there in 17, Malad. Therefore, the position that is internal payment running page 142.
Yes, yes.
Therefore, the position of law with regard to interpretation of terms of the contract is that the question as to whether a term of the contract is essential or not is to be viewed from the perspective of the employer and by the employer. Applying the aforesaid position of law to the present case has been the contention of respondent one. The format for bank guarantee was not followed strictly by the state. Relaxation given was not uniform. In the respondent number 1 was singled out. Well, this is what the law is. Now, well, it kindly comes to paragraph
22.
23, Malad.
23. Red court should refrain to itself from.
Yes, Malad. Malad, there's a very interesting paragraph here, Malad. Malad, sometimes, Malad, since I appear for the state, I feel these are very good judgments. Malad, my lords had also been on this side, Malad. Then when I go back to the petitioner side, I feel Malad, these judges are very dangerous judgments. Kindly see. In view of the above judgments of this court, the writ court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a tenderer. The court does not have the expertise to examine the terms and conditions of present-day economic activities of the state, and this limitation should be kept in view. Court should be even more reluctant in interfering with contracts involving technical issues if there is a requirement of the necessary expertise to adjudicate upon such issues. The approach of the court should not be not to find faults with magnifying glass in its hands. Rather, the court should examine as to whether the decision-making process is after complying with the procedure contemplated by the tender condition. If the court, kindly, this is very important. If the court finds that there is total arbitrariness or that the tender has been granted in a malafide manner, still the court should refrain from interfering in the grant of tender. Well, this is the sudden change. But instead relegate the parties to seek damages for the wrongful exclusion rather than to injunct the execution of the contract. The injunction or interpretation of the tender leads to additional costs to the state and is also against public interest. The state and its citizens suffer twice.
Yes.
So, Malad, here, Malad, your lordship sees a sudden change, saying that even if there is arbitrariness,
you have to go.
You go to damages.
Damages.
The court should not interfere. And the last judgment is very recent judgment, Malad. Sorry. This is the last judgment which you just found, Malad.
Tata Motors.
This is the Tata Motors, Malad. 2023 SCC Online Supreme Court 671. 671.
Paragraphs.
Malad. Malad, paragraph 50, 51, 52. And 53, Malad. Malad, may I just read, Malad, paragraph 52, if your lordship permits me, Malad? Ordinarily, a writ court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a tenderer unless sometimes very gross or palpable is pointed out. The court ordinarily should not interfere in matters relating to tender or contract. To set at naught the entire tender process at the stage where the contract is well underway would not be in a public interest. Initiating a fresh tender process at this stage may consume a lot of time. and also loss to the public exchange to the tune of crores of rupees. The financial burden implication of the public exchange that the state may have to meet with if the court directs issue of a fresh tender notice. One of guiding factors the court should keep in mind. Then the law relating to tender, paragraph 53. By the state and public sector corporation was reviewed on Air India versus Cochin. It was held that the award of a contract with a private party or by a state is essentially a commercial transaction. Here there is no scope of any natural justice. It can choose its own method to arrive at a decision. It's free to grant any relaxation for bona fide reasons if the tender conditions permit such a relaxation. Then Malakai sees this next sentence, even when some defect is found in the decision-making process, the court must exercise the discretionary power under Article 20 with great caution and should exercise it only in furtherance of public interest and not merely the making out of a legal point. The court should always keep the larger public interest in mind in order to decide whether its intervention is called for or not. Only when it comes to a conclusion the overwhelming public interest requires interference, the court should interfere. That finding is not there, Malak.
Yes.
Now, Malak, but I know I've said two. Malak, may I just only Malak, this is a proposition. If your lordship wants, I can give Malak with humility, Malak. Again, Malak, these are statements which I make, Malak. Malak, the learned single judge was bound by the judgment of the division bench. Not following that, Malak, would tantamount to a judicial impropriety. That was binding. And the honorable judge also says it's on similar facts.
Correct.
After that, Malad, passing an order contrary to a division bench or judgment, Malad, because I say it would be bound because I've taken the point, is bound by res judicata, constructive res judicata. Malad, I have a judgment if your lordship wants, Malad. This is Malad 1982, two Supreme Court cases, 499. Malad, this your lordship kindly takes internal page, Malad, running internal page of 514, Malad. This is part of paragraph 16. Acha right? Right. Ektai dekhabo ni, etai dekhabo.
Yes.
Yes, Malad. Malad, just somewhere in the middle, just about Malad, your lordship will find in italics Nuruddin Abdul Hussain, Malad, on the top, Malad. Just after that, the sentence, it may be pointed out.
Yes.
Here that the division bench decision of the Madhya Pradesh High Court, which was in terms binding on the learned judge of the High Court, and it was specifically submitted to us that even though the attention of the learned judge was invited, he neither referred to it or distinguished it. Times without number, this court has observed the consideration of judicial propriety and decorum require that if a learned single judge hearing a matter is inclined to take the view contrary to the earlier decision of a division bench of the same High Court, it would be judicial impropriety. To ignore the decision, but after referring to the binding decision, he may direct that the papers be placed with the Chief Justice of the High Court to enable him to constitute a larger bench to examine the question. Judicial Committee demands that the binding decision to which attention has been drawn should neither be ignored nor overlooked. Malad, here in this case, Malad, it has been noticed, but ultimate decision, Malad, has not been reached. Why it is not binding, that has not been reached. And why my submission that it is binding is not to be accepted, Malad, that is also not there.
Yes.
Malad, I again also have a Supreme Court which says even if it is pending before the Supreme Court, Malad, that still remains a binding precedent. If your lordship wants, I can give that also. Malad, this is Malad 1977, 3 Supreme Court cases, page 25. Malad, paragraph 25, it's the last page, Malad. No, Malad, this is last paragraph 25, Malad. Last page, sorry, paragraph 25. Our attention is drawn to a disquieting feature in the procedure adopted by the learned single judge in disposing of the appeal. The learned judge ignored the decision of another single judge of the same court who had earlier held in a similar case. The appeal by the state was not competent under section 377(1) CRPC. It is true that a decision is pending before this court in appeal by special leave. That, however, cannot be sufficient reason for the learned judge to ignore it and observe that it is unnecessary to keep back this matter till the Supreme Court decides the matter. When there's a decision of a coordinate court, this was the case of coordinate court, in our case, there is a hierarchy. It's open to the learned judge to differ from it, but in that case, the only judicial alternative was to refer it to a larger bench, not to dispose of them by taking a contrary view. Judicial discipline as well as decorum should suggest it as the only course. And these are my submissions. And your lordship, that bench, the earlier division bench, I'm also relying on it, as a precedent, because it's on the similar facts and on the same point of law.
And same party.
Same party. Same party. That's why I've taken the point of res judicata, constructive res judicata on the point of question of fact.
Yes. Yes, Mr. Datta.
But I need to take your lordship through some of the conditions of the contract or the tender. Well, at page 235, which my learned friend has placed before my lord, is the integrity pact which I have signed.
Correct.
The format of that integrity pact, your lordship would find at page 204. This is the format.
Yes.
Identical. And 255 is what 235 is what I have filed. Now kindly consider two other conditions of the NIT as to what am I to do with this integrity pact, or what is a bidder or a prospective bidder supposed to do with this integrity pact at the time of submission of the bids. Page 99 is the first one, page 115 is the second one. First, take page 99. It starts from page 98, that is clause 23 at the bottom of page 98. Implementation of the integrity pact. The integrity pact shall be applicable for tenders contracts of value of rupees so and so and above. DVC shall be entering into an integrity pact with the bidders as per format in the NIT, as per form so and so enclosed. The pro forma has to be returned by the bidder along with the techno-commercial bid, duly signed by the same signatory who signed the bid. That is who is duly authorized to sign the bid. Any bid not accompanied by the integrity pact duly signed by the bidder shall be rejected straight away.
Yes.
All pages of the integrity pact to be signed by the bidders, authorized signatory who signs the bid. In other words, entering into this pact would be the preliminary qualification. So the only thing that I'm supposed to do is to sign on all the pages of the integrity pact without adding, subtracting, deleting anything with in the integrity pact. The next clause is at page 115, 115. Under clause 29, the subclause.
Yes.
Clause 29, the subclause, integrity pact, vendors, contractors are required to unconditionally accept the integrity pact executed in plain paper as per format furnished by DVC. So I have got nothing to do except sign it. And I have done so.
Yes.
So, my lord, I have no scope to disclose anything along with the integrity pact.
Yes.
Now please come to Millard, page 144, where that clause 2, your lordships have been pleased to consider.
Yes.
And may I read from subclause 1? Well, the heading is obligations for proactive disclosures. Or in other words, even if not required, I am to disclose. And what is the purpose? That is also available in this clause itself. May I place it, Miller? I says procuring authorities as well as bidders, suppliers, contractors, and consultant service providers are obliged under the Code of Integrity for public procurement to suo motu proactively declare any conflict of interest coming under the definition above. Miller, the definition I'll place. Pre-existing or as and as soon as these arise at any stage in any procurement process or execution of contract, failure to do so would amount to violation of the Code of Integrity. Then please take II. Any bidder must declare whether asked or not in a bid document any previous transgressions such as a code of integrity with any entity in any country during the last 3 years of being debarred by any other procuring entity. Failure to do so would amount to what? Violation of the Code of Integrity. But I am supposed to disclose it. I have not disclosed it. What is the result? The result is violation of the Code of Integrity. Then III is the purpose. To encourage voluntary disclosures, such declarations would not mean automatic disqualification. This is very important. Would not mean automatic disqualification for the bidder making such declaration. The declared conflict of interest may be evaluated and mitigation steps, if possible, may be taken by the procuring entity. Similarly, voluntary reporting of previous transgression of the Code of Integrity elsewhere may be evaluated, and barring cases of various grades of debarment, an alert watch may be kept on the bidder's actions in the tender, etc., and subsequent watch.
Yes.
Therefore, my lord, my first submission would be Integrity Pact, I have no scope to disclose. Under clause 2, there is an obligation, but if I declare those also, or if there is a transgression also, it does not lead to disqualification. The purpose is to keep an alert watch, which means that not only disqualification, I may succeed also, and thereafter they will keep a watch on my activities.
But that stage is yet to come. They have not invoked this banning of business dealings.
Well, yes, I'm sorry.
But what they appear to have done is only to reject the technical bit.
Yes.
Because if this policy has to be implemented, then the guidelines prescribed for debarment has to be followed.
Yes.
Then reasonable opportunity, etc.
Yes.
So that stage is yet to come.
Yes, that is what, Miller, the Hon'ble single judge has at the end held, that you have virtually blacklisted them without.
What steps have you taken to conclude the criminal proceedings?
Well, may I say this, Miller? There are a number of things that I had to submit on that. First is made on the transgression aspect, my learned friend's interpretation. I'll address your lordship on that. But since a point has cropped up, first is, my lord, I am not being charge sheeted. Who is the I? The I is the company which is the bidder. Who has been charge sheeted? One of the directors of the company. my lord, law is well settled, my lord, in the criminal jurisprudence that if the investigating agency finds faults of the company is made an accused. If some employees, some director XYZ who is associated with the company, maybe the highest officer of the company, if he or she is charge sheeted, my lord, the company cannot be said to be a charge sheeted accused. Because in our country, my lord, a company can also be convicted. Therefore, the fact, but if required, I'll place those judgments before my lord. Therefore, the fact that the company has not been made an accused clearly goes to show, as per the interpretation of our High Courts and the Supreme Court, that the company was not found to be prima facie guilty of whatever has been alleged. Now, this is my first response to my lord's query. My second response is, though, my lord, at a subsequent stage, I cannot suppress facts from the court. My lord, today, my lord, this honorable court has also stayed that criminal case, but subsequently. Now, my lord, I take my learned friend's submission in regard to transgression. My lord, transgression, according to him, is not defined. Please have a relook to clause 2.2, 2.3.2. It may throw some light on what is transgression. Then I'll take what my learned friends understand as transgression. Any bidder must declare, whether asked or not, in a bid document, any previous transgression of such a code of integrity. Transgression, my lord, whatever may be the normal meaning, here, my lord, it is qualified with the next words, such as a code of integrity. My submission is, my lord, this transgression cannot be given the widest meaning.
Yes.
Now, my lord, I take my learned friend's submission that here transgression has to be given the widest meaning, which would include a criminal case. I'm sorry, not a criminal case, a criminal act. We go by their dates. I will not change any of the dates. Please come back to page 588, which is the impugned order before the Honorable Single Judge. Now, please take the first paragraph for the present, my lord, at page 588 on the transgression aspect.
Internal page number.
But it's running page 588, internal page is 12 in the second volume, my lord, in the second volume. But I'm not on, my lord, the order of on the judgment under appeal. But I'm on the second volume of the stay application.
Oh, grounds of rejection.
Yes.
Okay.
Oh, sorry, sorry. I'm so sorry, but I may have used the wrong expression.
Yes.
Please take paragraph 1 over here. I go by what they say. Fraudulent practice was noticed against you related to pilfering of DVC's transported good quality coal and replacement of the same with some extraneous materials like boulder stones, mud stones, etc., while executing a coal transportation contract of so and so. Full stop. The same was proved on 1/6/2018. May I pause here for a moment? Who has proved it? This is the DVC's, whatever officers, they have proved it. Therefore, the transgression, even if it includes a criminal act, had taken place on or before 1st of June 2018. Then kindly may I read. RTPS officials in presence of the contractor's representative, letter was issued to you on 2/6/2018 intimating this incident of ill practice by them. FIR was registered on 9/6 and charge sheet on 24th of October. Therefore, my lord, whatever is the transgression, assuming it includes a criminal act that has taken place on or before 1st of June 2018, therefore, that should be the starting point to calculate 3 years. The next is the date of the charge sheet. According to me, my lord, charge sheet was not filed against me. Therefore, this cannot bind me or implicate me in the tender process. Be that as it may, my lord, the date of the charge sheet cannot be referred to for the purpose of calculating the period of 3 years. Why? Because charge sheet, as your lordships know, is a result of investigation. A result of the investigation may result in two things. One is the investigating authority may think that no charge sheet is required to be filed. The matter is to be closed. Nothing has been found out, or it may lead to a charge sheet. In either case, the act is not dependent upon the result of the investigation. What does the police or the investigating authority investigate? Or what do they do during investigation? They only try to collect the evidence in support of whatever has been alleged. If they find some materials, they proceed in one way. If they find no materials, they proceed in a different way. But the criminal act has got, the commission of the criminal act or the date of commission of the criminal act has got no connection with the result of the investigation. Positive, negative, whatever it is. Therefore, my lord, for the purpose of calculating this 3 years, the date of filing of the charges is irrelevant, qualified with the fact that I am not a charge, the petitioner is not a charge sheeted accused. Or in other words, my lord, filing of charge sheet is not a commission of transgression. Now, what is the pleading on this transgression? Please have a look to, my lord, page 5 of the stay application. But I'm sorry, my lord, I don't have that affidavit of which they have filed in Supreme Court where they have said the same thing. My lord, it starts at page 4, para 4. Sometimes in the month of October 2022, kindly skip over that. My lord, the next page, page number 5, about 8th line from the top, the sentence starting with the extreme right hand side.
The respondent number 1.
Yes. The respondent number 1 had in fact committed a transgression in the month of June 2018. And thereafter, the petition number 1 had made a complaint. And this is quite consistent with the law. I don't think, my lord, this can be denied also.
So if they have accepted it is transgression is in 2018 June, then 3 years is long.
3 years had passed. Now, my learned friend has placed, my lord, the definition of fraudulent practice at page 143.
Yes.
what is fraudulent practice? Because he goes to section 3, the second part, I have got submissions to make on that, but before that, fraudulent practice. Fraudulent practice, any omission or misrepresentation that may mislead or attempt to mislead, so that financial and other benefits may be obtained or an obligation avoided. This includes, etc. Milord, the expression fraudulent practice is not only an omission or misrepresentation, but it must have the effect of misleading or attempting to mislead so that I get some financial benefits. Or to avoid an obligation.
Yes.
But assuming that I had an obligation to disclose and I have not disclosed, assuming that it may result in a fraudulent practice if I had disclosed, please consider the definition itself, going by again Justice Frankfurter's principles, which our Supreme Court has accepted in Ramana Sethi's case, that an executive authority is rigorously bound by the standards by which they profess their action to be judged, and they have to follow them on the pain of invalidation. Now, because terms are laid down by them, I am to follow the terms, they are also to follow the term. Now, the term says that fraudulent practice is not everything and anything, or any omission or any misrepresentation. This omission or misrepresentation must result in, one, to mislead so that financial and other benefits can be obtained. But in my very respectful submission, Milord, assuming for argument's sake there was a transgression, this non-disclosure of the transgression would not have resulted in any financial benefits or to avoid any obligation. Now, Milord, I come back to Milord, the section 3 and 5. Either your Lordship takes it from page 204. Since your Lordships have possibly marked 235, may I place from 235?
Yes.
Well, may I start from clause section 2?
Yeah.
I think to clarify things, we need to look into section 2 also. The bidders, contractors commit themselves to take all measures necessary to prevent corruption. A future act. The bidders, contractors commit themselves to observe the following principles during participation in the tender process and during the contract. A, the bidder contractor will not directly or through any other person, firm, offer, promise, or give to any of the principals, employees involved in the tender process or the execution of the contract, or to any third person any material or benefit which he is not legally entitled to in order to obtain an exchange and obtain in exchange any advantage of any kind whatsoever during the tender process or during the execution of the contract.
I think A will not apply.
A will not apply. But these are all, Milord, subsequent.
Will not comment of offence relevant to IPC, PC Act. Will not use improper competition, personal gain, etc.
Yes. A, B, and C, your Lordship would find, Milord, these are all will not. Subsequent.
D.
Now D, the bidders of foreign origin shall disclose the name, etc. Possibly that is also not applicable. We are not a foreign origin bidder. E.
No. Second sentence. Similarly, bidders, contractors of Indian nationality, follow names of the foreign
principals, so not applicable. Kindly take E. Bidders will, when presenting their bid, disclose any and all payments made is committed or intends, etc., that is also not applicable in the facts of our case. F, bidders who have signed the integrity pact shall not approach the courts while representing the matter to IEMs, etc. Bidders will not instigate third persons to commit offences outlined above. So and so. Future date. Now kindly take 3. If the bidders before the award or during execution has committed a transgression through a violation of section 2 above, or in any other form such as to put his reliability or credibility in question, the principal is entitled to disqualify the bidder from the tender process or to terminate the contract if already signed, and to take action as per the procedure of banning of business dealings with the principal. Therefore, my lord, my understanding of, my lord, section 3 is that section 3 is a fallout of section 2. Number 1. And number 2, my lord, with all humility, my lord, it's against all my personal practice to accuse an advocate that some submission which has not been made before the court below should not be made before the appeal court. The submission made before this appeal court is that the second part of section 3 has been applied by the respondents. No such submission made before the learned single judge. I say this with all authority and conviction.
I'll put an affidavit.
Yes.
And above that, my lord, nothing is reflected, my lord, from page 588 that the second part of section 3 has been applied by the respondents. I mean the appellant over here.
During participation or during execution. So this is also to be present.
Therefore, my lord, in my very respectful submission also, my lord, assuming that the second part of the section 3 has been applied, then also, my lord, number 1, it does not get reflected from page 588. And number 2, it cannot put my reliability in question because there is no allegations of transgression post-investigation against me or against the bidder. Therefore, my lord, either part of section 3 in my very humble submission are inapplicable. Now, please consider, my lord, what is arbitrariness? Because all the judgments of the Supreme Court which says that if the author of the tender has interpreted a condition in a particular manner, the court will normally not interfere. What will the court do is, the only window that is open is arbitrary and extraneous consideration.
Malefactors.
And malefactors. Our division bench in the previous round of litigation has also said so.
Yes.
Which is now before the Honorable Supreme Court. I'll take my learned friend's point of res judicata. Please have a look, Milord. I'm so sorry, Milord. I have only one copy. Copy. Supreme Court. Milord, the Supreme Court says, Milord, we have heard the learned counsel for the parties preliminarily. The matter requires consideration. This is the matter, etc. Therefore, Milord, the Honorable Supreme Court is also of the view that this is not a case of the previous writ petition, but the previous writ petition where the ground was the same. Here, first they say administrative ground, and then they give the reasons. In that case, or which is before the Supreme Court between the same parties, there they had said initially techno commercially non-compliant instead of administrative ground. But when again we sought for an reason, the same reasons were given. Now, the Supreme Court also says on the same aspect that the matter requires consideration. In other words, the Supreme Court has not put a full stop. Now, please consider, my lord, whether, my lord, the window that the Supreme Court has kept open is applicable in the facts of our case. Malafides, extraneous consideration, and arbitrariness. Well, first is, my lord, arbitrariness, my lord, in my very respectful submission. To put it in one word, according to me, is something which is whimsical. Why I say whimsical? You are the author of the document. You were abreast of the so-called transgression from day one. You have conducted an inquiry on 1st of June. You have registered an FIR. And thereafter, of course, the police and the administration and the state is to carry forward with the prosecution. You have participated in arbitration. You have allowed me in 14 tenders to participate, which were all beyond these 3 years, except one. Except one, I'll show that. And today you are coming and saying that no, you are guilty of X, Y, and Z. And this has started in a series. The series started with the one which is now pending before the Supreme Court. And the follow-up in the series is these two matters before my lord. Therefore, my lord, nothing had happened in between for the DVC or the appellant to take a contrary view today. And therefore, my lord, in my very respectful submission, it is not only malafide, my lord, it is arbitrary. So the window which the Supreme Court has kept open, my lord, in my respectful submission applies in this case. And I'll demonstrate from the judgment under appeal that this has been taken care of by the Honorable Single Judge. The other party's extraneous consideration.
Yes.
My lord, if I am right in my understanding that the criminal case has not, the investigation has not resulted in the bidder being made an accused, then, my lord, reference to that becomes an extraneous consideration. There is nothing on record that the respondents have considered this aspect and may have come to a wrong finding. I can understand they consider it and come to a wrong finding. Your lordship may say that, no, why will we disturb that finding?
Yes.
My lord, NG projects has been heavily relied upon. Please have a look to Miller NG projects once more, Miller. 2022, volume 6, Supreme Court cases 127.
Yes.
Please take paragraph 22. The satisfaction whether a bidder satisfies the tender condition is primarily upon the authority inviting the bids. Such authority is aware of the expectations from the tenderers while evaluating the consequences of non-performance. In the tender in question, there were 15 bidders. Bids of 13 tenderers were found to be unresponsive, that is, not satisfying the tender condition. The writ petitioner is one of them. The next sentence is very important for me. It is not the case of the writ petitioner that the action of the technical evaluation committee was actuated by extraneous considerations or was malafide. Therefore, on the same set of facts, Different conclusions can be arrived at in a bona fide manner by the technical evaluation committee. Since the view of the technical evaluation committee was not to the liking of the petitioner, such a decision does not warrant interference in the grant of contract to a successful bidder. Therefore, my lord, over there, I'm sorry,
No. There they did not challenge it on account.
on extraneous and malafide. But here, my lord, the point was in regard to submission of a bank guarantee relating to which was not in the form prescribed.
Yes.
Now, what does the Supreme Court say in that paragraph 23, which my learned friend has relied? Please take placitum G.
Yes.
The approach of the court should not, should be not to find fault with magnifying glasses in its hand. Rather, the court should examine as to whether the decision-making process is after complying with the procedure contemplated by the tender condition. This is what I am submitting, or I have submitted before the learned single judge. That you have laid down the procedure, these are the conditions, these does not apply in my case. But I am not a case before this court challenging an interpretation of a tender condition or a set of tender condition. I have never said that this interpretation is wrong. I have not invited the court to find out the validity of the interpretation or the soundness of the interpretation. I say that I have got nothing to do but to sign the integrity pact. I have no obligation to disclosure. If you say that I have an obligation to disclosure, that obligation has ended with the passage of 3 years from the date of commission.
Alleged.
Therefore, my lord, I had not invited the court to go for an interpretation of their decision. But only one thing, I'm so sorry, my lord, I don't have it. In fact, there is a very, very short judgment of the Supreme Court considering NG project. Please permit me to give it by 2 o'clock or any time, where the Supreme Court itself said that NG project has not closed the door once and for all. There, the High Court refused to exercise jurisdiction relying upon.
The learned Red Court has.
Yes, yes.
After noting all the decisions.
Right.
In that paragraph, we saw that.
Now, please consider, my lord, the judgment, if I may place it, my lord, in my own way, the judgment under appeal. Please take paragraph 10 of the judgment in internal page 6.
Yes.
I'm sorry, paragraph 9 first. It is important to note that the occurrence of the past transaction has been restricted to 3 years prior to the date of tender or the date of furnishing of documents of the bidder. Section 5 therefore limits the period of transgression to a finite period. Section 5 also becomes relevant when seen against the first ground stated in the DVC's letter dated 24th of November, which mentions fraudulent practice and pilferage. The first ground, however, specifies that the alleged offense was proved on 1/6/2018 and an FIR was registered on 9/6/2018, followed by a charge sheet on 24/10/2019. These dates are significant since proving of the offense on 1/6/2018 would naturally mean that the alleged offense was committed by the petitioner at least before June 2018. Although the word transgression has not been defined in the Integrity Pact, even if it is assumed that the petitioner was guilty of fraudulent practice pilferage, the said transgression falls beyond 3-year window under Section 5 of the Integrity Pact. The tender was issued by DVC on 7/9/2022. 3 years had therefore clearly passed, even if the FIR is taken as the starting point. It is also significant that Section 5(2) authorizes the principal tendering authority to disqualify a bidder from the tendering process or ban the bidder from future business dealings only if the bidder makes incorrect statement on the subject of past transaction under section 5(1). Although the letter of DVC dated 24/11 does not mention any other section of the Integrity Pact, counsel appearing for the parties have referred to other clauses of the tender documents, which the court also proposed to deal with. Now, the court is therefore considering clause 2.3. Clause 2.3 of so and so provides an obligation on the part of the bidder to make proactive disclosures. Clause 2.3 II requires the bidder to declare previous transactions, whether asked or not in a bid document during the last 3 years, or of being debarred by any other procuring entity. Clause 2.3 III relaxes the obligation to the extent of stating that a declaration of transgression made by a bidder under clause 2.3 II committed during the last 3 years or debarment would not lead to automatic disqualification, but may be evaluated and mitigation steps may be taken. Clause 2.3 III also provides for keeping an alert watch on the bidder's action. Therefore, clause 2.3 II and III read together indicates that a bidder is required to disclose previous transgressions committed in the last 3 years, and further that the disclosure would not result in automatic disqualification. The voluntary disclosure is for the purpose of monitoring the bidder's activities. The contention of DVC that the petitioner failed to disclose the commission of the fraudulent activities, pilferage, and hence violated section 3 of the Integrity Pact must be read strictly in accordance with the specific requirement of section 2, section 3, and section 5 of the Integrity Pact, as well as clause 2.3 of the policy. From a conjoined reading of all these conditions, it is clear that the obligation on the part of the petitioner was to disclose past transactions which occurred in the 3 years prior to the date of the tender, and would hence not cover the alleged fraudulent activities which occurred before June 2018, which was the specific case stated by the DVC in the letter dated so and so. The issue which emerges is whether the tender condition read with the Integrity Pact structured by the DVC contemplates excluding a bidder by reason of transgression under the sections of the Integrity Pact where transgression has taken place beyond the 3-year reckoning. The scheme of the terms and conditions makes it clear that the culpability with regard to violation of any of the sections resulting in transgression must relate to a fraudulent practice which is limited to 3 years preceding the tender. The sharpness of the penalty has somewhat been blunted by clause 2.3 III of the policy without withholding, withholding and banning of business dealings in the manner stated above. Hence, the argument that the petitioner committed violation of section 3 of the Integrity Pact by failing to disclose the FIR and the charge sheet of so and so, and hence transgress the integrity of the process, is inconsistent with both the policy of banning as well as the Integrity Pact. Then, my lord, her ladyship considers at paragraph 16 the arbitration. My lord, in an arbitration, my lord, I don't think, my lord, I need to trouble your lordship with that. Whatever is the finding is there, in the judicial process that will be considered, that is being considered. Your lordship would kindly not consider it for the present. Now, my lord, the honorable judge considers the Supreme Court decisions, paragraph 18, 19, where in paragraph 19, my lord, after collating the Supreme Court decisions, my lord, the sentence is, these decisions reinforce the view that the author of the tender document is the best judge to understand the requirement of the tender, and the court should not disturb the interpretation given by the tendering authority. Next paragraph is important. All the decisions, however, preserve the window for arbitrariness and a manner fide award or rejection of a tender, including for extraneous considerations. Any factor which would sully the purity of the selection can always be brought to the Red Court. Silpi construction took into account this very proposition to hold that the court, being the guardian of fundamental rights, is duty bound to interfere when there is arbitrariness, irrationality, malafide, and bias. So and so explained, an arbitrary action being capricious, one that defies logic and is subjective to the point being irrational. The action is whimsical and lacks reasonable explanation in so and so to hold that the scope of judicial review is limited to unreasonableness, illegality, and procedural impropriety. In Jagdish Mandal, the Supreme Court came to a similar view and held that judicial review of administrative action is to prevent arbitrariness, irrationality, unreasonableness, bias, and malafidus. Then, my lord, the court goes with those that since it is beyond
3 years,
so therefore
it is arbitrary and unreasonable.
yes. And finally, the court at paragraph 24 says that an order of rejection at this stage would amount to virtually blacklisting without hearing. Therefore, my lord, in my very respectful submission, my lord, there is no
Now,
error. Yes,
during the pendency of the writ petition, there is an interim order.
all along.
So you have not proceeded for, they have not.
There are two things that I would like to say. From the day one, there was interim order. Number two, my lord, no vacating application filed. That was also recorded somewhere. That was
No, the-
recorded somewhere.
Learned single judge records this
Yes.
in para
Okay.
24, I think.
Yes. At a stage, they had challenged one of the orders extending the interim order. When, my lord, your lordships, this bench, honorable bench was pleased to say that no, we don't want to interfere at this stage. Go back, get the matter thrashed out over there. Therefore, my lord, we were all along enjoying the interim order. Kindly permit me 1 week's time, more or less, my lord, we have finished. To, my lord, deal with, my lord, the stay application.
Not required. sir.
Very, very well.
You are
And, my
going to
lord,
decide on the question of
very,
law
very well.
and the fact regarding the interpretation.
Very
of
well, very
the
well.
words of-
I leave it to the
That
court.
is enough.
The only thing I have left with is res judicata. The order of the Supreme Court says, which I have handed up, it requires consideration. So there is no res, no judicata. Res is thing, judicata is adjudicated. The Supreme Court is still in the process of adjudication. Therefore, it cannot be said that it has been finally decided. Only thing that can be said is, because my lord, here in the
I think Government Leader's argument was that it binds the single bench.
yes,
The ratio
yes,
of the division bench.
yes,
Inter partes.
right, right. I'll tell you.
And slightly he added a dose of res judicata to
No, my lord,
press on that point of res judicata. But he said judicial discipline, etc.
my lord, here, my lord, that would not apply. Why, my lord? May I only clarify my thoughts? My lord, your lordships have distinguished between what is the effect of a stay of an order and setting aside of an order. Staying of an order is only deferring the execution of the order, whereas setting aside of the order means the order goes.
Everything goes.
Now, therefore, even if there is a stay, the law laid down operates. The law which has been laid down by the previous division bench is that in case of arbitrariness, malafidus, the court can interfere. And that law has been applied over here. Therefore, in addition to that, my lord, all those other judgments are also there. Therefore, my lord, this cannot be said to be a case of judicial impropriety, because the honorable single judge, keeping in mind the previous order of the division bench of our High Court, that the exceptions are arbitrariness, malafidus, and extraneous consideration, have decided the issue. And have also relied upon the Supreme Court judgments, which keeps the window. These are my submissions.
A very quick submission.
What else you want?
Very quick, my lord.
So for the next 2 weeks, no case of Government Leader and no case of Mr. Dattu.
I don't have so many cases. I may,
But
your
only
lordship
one-
may not see my face for the
Then allows
next 2
me
weeks.
to make one submission, my lord. Because unexpectedly, a submission has been made by my learned friend on whether a submission was made before the learned single bench or not. Because this is a very serious allegation which Mr. Dotto has made. My lord, may I say two things? One is, my lord, we had put in notes before the learned single judge. I have a copy of the note, my lord. Note to the notes. There I have taken this point specifically. My lord, your lordship knows now, the CPC has also been amended to incorporate such notes so that we now have something to validate what we have said. Very unfortunate. Though very unfortunate. Today, Mr. Dotto said so. With humility, I submit. In sometimes we do not remain in court. Just now I went out, my lord. But I don't think he has been properly been instructed on this. As a matter of fact, the same example which I gave your lordship, that if I know that there is someone who has stolen from my house, will I again call him back? That same example I had given to the learned single judge. And I'm ready to put in an affidavit. I will affirm it if required. Now, that is one point. Now, my lord, I'm relying on Mr. Dotto's interpretation of stay and setting aside. He has just now come, and I understand why he wants to give an affidavit to my application, because he wants to put it on record that he says so, that there is a stay of the charge sheet, I believe. But the same principles apply there. Stay is not quashing. It is not setting aside.
But there is no stay with the Supreme.
That is what he's just submitted.
No.
Sorry, Manoj.
What Mr. Atto's interpretation is, Supreme Court has not, it is heard the matter and said that it requires exam.
I'm not on that, Manoj. I'm not on that stay.
Hmm.
He just said that the criminal charge sheet has been challenged and is in state. I will say that has got no implication on this. And my lord, your lordship will find in the honorable single, if your lordship wants, I can get that affidavit also before your lordship. Whereas lordship has recorded that the affidavit filed before in the special leave petition was also relied upon. My learned friends relied upon it. There also, if I bring it, your lordship will find that that section 3 second part has been referred to. So with humility, if your lordship wants, I can get that, I can put in an affidavit, whatever it is. But this case of my lord, the petition or the writ petitioner not being charge sheeted is being taken for the first time before your lordship.
No, this is before pursuant to the query of the court. That was not my
This is
argument.
being taken for the first time,
It will be illegal.
but your lordship, only one page your lordship just keeps note of. I don't want to go into that. The charge sheet, if your lordship just reads that, your lordship will find that
Where is the charge sheet?
page 37. I'm sorry. 36, your lordship will find. This is column number 17. Your lordship knows in the charge sheet there's a column, my lord. In column 17, the facts of the case has been given. Where, my lord, there is a specific allegation with regard to this company, BLA Projects Private Limited. And, my lord, then, my lord, there is a reference that the accused owner is Ajay Agarwal. The first paragraph which lordship sees, it's just just for the first sentence. So, Messrs. BLA Projects Kolkata violate various provisions of the contract. Has the lordship got that, Malad? First paragraph at page 36.
Violated the various.
Then, Malad kindly sees next paragraph. Accused owner, just the last sentence, namely Ajay Agarwal.
Not the company.
As the managing director. And the third paragraph. So Ajay Agarwal is not representing himself. He has been made a party and charged as the managing director of my learned friend's client. The board. It is the board, not Ajay Agarwal himself. Malad, these submissions, Malad, only now, Malad, I will just make one last submission. Malad, this is what the Supreme Court has said. Do not take out a magnifying glass and go into this. This is what my learned friend is asking your lordship to do. With humility, I submit.
We don't have a magnifying.
Malad, I was very so, Malad, this is what I'm trying to submit.
That's it. We'll
Well,
decide.
these are my submissions.
Thank you.
Very good.
We have heard.
We are very grateful, Mr.
Hariban Ray and counsel for the appellant and Mr. Kishore Datti. Judgment reserved.
Yes.
There are two matters.
Yes,
Matters, identical.
only yes, not identical, but I must bring it to your lordship's notice, my lord. With regard to 894, I have said that the final reverse bias has been, reverse bias,
Reverse auction.
reverse auction has been held and the final bidder has been obtained. Now, my lord, if your lordship is not minded to allow the appeal, then my lord will kindly consider that then a new bid has to be done.
Is it a common order by the learned?
Yes,
Yes.
In 895 reverse,
894 reverse has been completed and the final bidder has been
what is it called? Reverse?
auction.
Reverse auction.
Reverse re-auction.
কবে হয়েছে রে ডেটটা?
16 November.
16 অনেকদিন আগে।
তোমার ইনক্রিমেন্টের আগে। So, my lord, I will just point out, my lord, now if your lordship is not minded to allow the appeal, my lord, then your lordship will kindly consider, because in that I cannot give effect to what has been said by the learned single judge. Then I will have to go for a new fresh tender. In the other one, my lord, yes, the financial bid has not yet been opened in 895. I wanted to point it out. These two I needed to point out because these are, I mean, judicial, jurisdictional facts, if I may say so.
Thank you.
Grateful.
I'm grateful. Sir.
Yes.
Serial number 6.
My lord, I for the respondent number 4 and 5, private respondents in the repetition.
And for the petitioners. My lord, here in this case, my lord, very short question is it. My lord, two parts are there in any criminal matters or whatever may be, where the reed court can interfere. One part is that means that the reed court is not powerless to exercise its power. So for the protection of a citizen, here the senior citizen, my lord. The senior citizen is the 86 years of age, suffering from cancer 2 stage and on the verge of death. My lord, his wife is also, my lord, that a sickly wife, and at the age of 76, she has been put under arrest. For no reason that, well, she has come to commit attempt to murder. And the only offense means which the police always apply, that means section 307, at least blatantly, that means that taking this advantage, a man may be put in prison behind the bar. My lord, here in this case, my lord, the only son, he does not remain here, at least he decides Madras or Bangalore. My lord, taking chance of this, when this couple means both the parents are here, the citizens, senior citizens, my lord, managing one deed, my lord, that you have sold out your property. And the checks which were shown there, it's the report of the bank concerned that there is no such execution, no such, these checks have been bounced, there is no such. Therefore, physically, only a particular sum, at least very little negligible amount was paid to them, it has been told. Our submission is that nothing has been paid to us, and these hooligans, they are, means with the help of the police and taking all the guards and protections and taking all assistance from the police, they are trying to encroach our property. That was the real story behind this case. Now, my lord, when we approached before the Hon'ble single bench with the appropriate writ, there, my lord, we have made the specific, my lord, our prayer was there that that means that I cannot be or I should not be dispossessed from my existing position. And we, the old couple are here, old citizens are here, we must have to be protected. Up to the, my lord, the superintendent of police and to all the higher authorities that have been intimated. But, my lord, none came to rescue us. My lord, one case was filed that in this way, this was done. Police did not take any step. Thereafter, when the writ court, my lord, at the time of the hearing, even the accused persons, the named accused persons, they were not arrested by the police, or rather any explanation was asked from them why they are making constant disturbance to this couple. My lord, ultimately what happened, my lord?
But the learned judge records the charge sheet has been laid on 31st October 2021. under 420 and section 34 IPC.
Is therefore, my lord, that the
107
My lord.
CRPC also.
yes.
Now, what happened to the criminal case?
Therefore, my lord, what I am to say,
But
if a mere filing of the charge sheet, whether
no. See, you are filing a writ petition
Yes.
alleging police inaction.
yes,
It is not a case of police inaction. FIR has been investigated, charge sheet has
is
been
it
filed.
so? Was it my
No,
prayer?
suppose you say that some other sections have to be done. It is well open to you to go to the concerned court
Yes,
and add.
yes,
file
that is
application.
another chapter that we have done.
That is one. Secondly, it is a property transaction between two private parties, your clients and the private respondent. You approach the civil court and say that this transaction is fraudulent.
No problem. Everything has been taken.
Where?
We have taken resort to civil court.
Yes.
We have taken resort to criminal court. And also that means that the revisional application is also pending here.
What can a writ
But,
court do?
but my lord, that the writ court, so far the protection of the citizens of the country. Your lordship kindly see, my lord, the judgments are with us. Your lordships are well aware. Series of judgments are there. Kindly have a look, my lord. My lord, does it necessarily mean that the protection part will be omitted? My lord, if as an eyewash, if the police will simply, my lord, file a charge sheet, at least when has been asked for by the writ court, and when the government advocate will put charge upon him, then he will say, my lord, what is the explanation? The private respondent is here. What is the state? What is the state? Reluctance on the part of the state is to be seen. Private respondent is really coming forward, but the state is reluctant. What is the
Now, have they?
my lord? I think, my lord, that here at this juncture, my lord, that we have served the copy to all the parties, to the state specifically. This is our affidavit, my lord, that the affidavit service.
No, they have.
My lord, let my lord that the particular, my lord, that the either Advocate General or my lord that the GP concerned or the appropriate government representatives, my lord, kindly have a look.
If he is aggrieved, the state is not represented, my lord, I can tender a pay.
Yes.
Have they rejected your request for police protection?
That I am to say that they have virtually how they have rejected, how they have proceeded.
There are two from 20.
My lord, kindly have a look. What I am saying, don't have a look to this.
FIR was registered in the year 2020.
Yes.
We are in 2023.
Now go through.
The petitioners are alive till today. And where is the threat perception?
Your lordship,
police is not there for individuals to be protected, for protecting law and order. Please produce some threat perception.
I am producing here and now, my lord, that our
No, not before us, before the concerned police. You make a fresh petition.
We'll consider.
We will direct them.
No, your lordship will kindly see, my lord, that the one application we have filed it, my lord, the supplementary affidavit. Your lordship kindly see, my lord, supplementary. কপি দিয়েছি তোকে
আরেকটা দাও না
আমি পাইনি
এবার কোনটা তারা তোকে দিয়ে যান তুই বল কালকে টাইম নিয়ে আবার
আমি
কালকে নে
two copies.
two copies are there
Due to supplement. Category of service.
oh yes তুই কি চাস অন্যদিন করবি কালকে করবি কপি একটাই আছে
দিয়ে দেবেন একটা ঠিক আছে
my lord what I am to say if your lordship kindly see these are the development. Here your lordships will kindly find.
And the petitioner's son has been arrested, wife and son. And now they have obtained bail.
My lord, under which, my lord, that when they have been put under arrest, then they were told that, well, I am making compromise, and on that basis, that means they have been given it. Both parties, police has arrested my lord for so, my lord, when we have filed and lodged another complaint, then police took one thing, that is police remained silent. Then police remains the other side, they managed in this way.
Let the superintendent of police inquire into the matter.
Certainly, that was fine.
Because inspector has lodged some FIR.
True.
Now in 2023, his son and wife have been arrested.
87 years old, is before your lordship, let them make a representation before the SP.
What is your case?
May I submit this? My lord, what my learned friend is trying to do in the garb of this prayer is that restoration of possession.
That can't
That can be done.
Exactly.
The restoration of possession is what? First of all, you will have to get poison, then restoration. First of all, you will have to prove that how you have got poison in over one's property.
Yes.
Therefore, that a man cannot be evicted from his property. My lord, Naya Society's case, a man cannot be evicted from his poison without due process of law. Even a trespasser can't be. Long back, my lord, in the 1967, my lord, it's the settled principle of the law, which has not yet been reversed. My lord, that if a man, admittedly, I am in possession of the property, I'm the owner of the property, you have purchased it, if you claim so, then how first you prove that I have been dispossessed? Therefore, my lord, that this is the main question, my lord, what it has come out. The poison is poison. My poison should not be disturbed, my lord.
That issue we can't decide in a writ petition.
No, my lord, that poison can be decided, my lord, that when it has come out from the private state, my lord, side,
we will
my lord, my protection cannot be, my lord, protected. My poison cannot be protected by the writ court. My lord, I am showing one after the other judgments, my lord. There's so many judgments are there before the Hon'ble Court. If I am in possession, if I am in ownership, if everything is with me, whether any man can come to disturb me. My lord, there's a series of, my lord, you will also kindly see, my lord, that how the police has acted here. My lord, that if you will also kindly see that the police has done contemptuous act. My lord, that the interference in the due course of administration of justice. My lord, that when they are, if you will also kindly see the judgments, my lord, that here you will also kindly see, that means that the materials clearly justified the grant of relief paid for. Here in this case, my lord, the writ petition has been disposed of, but with no direction upon the police how they have acted with it. Simply by the, my lord, that only on the submission that the police has filed the charge sheet, it is done. But my lord, that what the duty of it to protect the citizen, the writ court cannot ignore its duty. Writ court is to see that the particular authority and concern, how they have protected, how they have investigated it by way of affidavit. In that case, when there was affidavit filed by the concerned police officer, then it was found that there is malafide practice, there is interference to the due course of administration of justice. But had there been the on those single benches judgment.
Did you file your affidavit?
No, I am,
Yes, they have not filed even.
You have not filed your affidavit.
Yes.
No.
File your affidavit.
Yes. That's
To bring everything on record.
I'll do that. But kindly do not give any interim protection. Not
Nothing
only
can be given. What interim protection?
that is there. And another thing, I wanted to point it
Learned
out.
advocates for the response.
On the point of delay, I have something to submit. Whether this should be at all admitted or not.
In 3 weeks from date, reply if any, within 2 weeks thereafter. List the matter. 3 plus 2. Next.
May I have a
And
copy?
in the meantime, protection, my lord, that is the PF.
Next, please.
My lord.
Serial number
Yes,
7.
and get one.
Yes. What is this?
Item 7, I say, my lord, at the outset, I should submit to my lords, this is an order, my lord, passed on 22nd May 2023 by my lord, Mr. Justice Hiranmoy Bhattacharya. Therefore, my lord, I was hesitating, my lord, to.
Since, please take notes. Since this appeal has been against an order passed by one of us, within bracket, Honorable Justice Hiranmoy Bhattacharya. Let the appeal be listed before some other honorable judge.
My lord, I will be making a letter, my lord, to the to my lord secretary, my lord, for assignment of the matter.
Yes, today if you give it, today evening I will assign.
I'm grateful to my lord.
Next.
Serial number 8.
Yes, my lord. And I am appearing for an on behalf of the authority concerned.
I am appearing on behalf of the appellant, my lord. Here, my lord, petitioner is one of the villagers, my lord, 4,000 to 5,000 residing one village, my lord. This is the entry point of this village, my lord. Two promoters construction, my lord, without any sanction plan, my lord. After that, my lord, recent, my lord, one got a sanction plan from the, my lord, Panchayat Samiti authority, my lord. Entire block, the, my lord, road, my lord. This is the ambulance and, my lord, fire brigade. Don't entry. This, the, my lord, kindly have a look. This picture photographs, first of all, my lord, my petition, page number 29. This is the picture, my lord.
May I file
And
the
my lord,
affidavit?
my argue this matter, my lord, this is the 29. This is the picture. This is the entry point of our villager. Or this is the my lord 29 of my application, my lord.
Yes.
Lord, kindly have a look. Photographs. These photographs, my lord, this is the entry. My lord, this block without any proper space, my lord, this is the block, my lord. The respondent number 9 and 10, my lord. What is the order by the Jela Parishad, my lord? Kindly come to page, my lord, page number 24. 24, my lord, 23rd September 2022. My lord, that you have been, my lord, respondent number 9 and 10. My lord, 2022. My lord, that you have been carrying out an unauthorized Paka construction without obtaining prior approval of the Jela Parishad, which act so and so, the provision act so and so. Please stop all further construction and so cause within 7 days. Why the said unauthorized construction will not be removed, and my lord, so and so, so and so. After that, my lord, page number 26. Page number 26. And my lord, this is the third paragraph, my lord. My lord, dated, my lord, November 2022. My lord, in the hearing, same, my lord, my lord, respondent number 9 hearing, my lord. So and so, building plan from the local Panchayat Samiti. Sub-assistant engineer, Howrah Jela Parishad inspected the site on 21st, so and found the building of, my lord, respondent number 10. My lord, my learned friend appearing on behalf of the respondent number 10.
I'm appearing for respondent number 10.
10. My lord, Kartik Kumar Gupta is under construction. Ground floor roof has been completed and first floor roof is going on.
All right. Don't know what action was taken after that.
My lord, no action is taken. My lord, illegal construction. My lord, kindly have a look. The abuse of the process of law, my lord, stop the petitioner and my lord, other villagers, my lord.
Who's appearing for Howrah Jila Parishad?
Yes, my lord. Kindly have a report.
What happened after this?
Lord, may I just only one thing, Lord, may I interrupt? Lord, kindly looks at, Lord, I am appearing only on behalf of the respondent number 10. The respondent number 10, my lord, so far as regards this impugn, my lord, this 18th November 2020 memorandum is concerned, that is at page 26 of my lord's brief. The Jila Parishad has conducted an inquiry, hearing was being done. He has found that, yes, I do have a sanction and revised sanction plan, and there are certain minor deviation which was directed to be regularized as per their bylaws. So, my lord, that bylaws, my lord, I have prayed for regularization.
What about 9th respondent?
Yes, 9th, my lord, I am not representing. So far as regards 10 is concerned, my lord, that was resolved. And before a public interest litigation, my lord, he cannot challenge this memorandum because that he has to approach, my lord, before the group 5.
He is not challenging it. What he says is, when admittedly there is violation, the authority is not taking any
That is
action.
in respect of respondent number 9, my lord, I am not standing in the way.
Kindly see page 27, Miller. Already authority, my lord, bottom second para from second para, in view of the above state facts and documents and statements of the party and report, sub-assistant engineer, Howrah Jila.
But how will you regularize it, madam, when there is no side setback?
Yes.
Yes.
You can't regularize it. How is he advising him? Without any sanction plan, he will construct. How you will regularize it? Who's appearing for the 9th respondent?
9th, my lord, from the beginning, my lord, I believe no one is appearing.
No, you have to demolish it.
My lord.
There is a provision for regularization.
No, illegal.
According to
See, then what is the purpose of?
Rule 15 of bylaws of our Jila Parishad.
My lord, that is there. They have framed this. My lord, being an officer of the court, I must inform your lordship. Before Lord, the Group 5 court, Lord, also the violence of this Lord bylaw is being challenged. Lord, that is the hearing is going.
You file your affidavit. You have
Hearing is
heard the learned counsels for the parties. Though notice has been served, now the 9th respondent.
Direction for affidavit was filed. Lord, they have filed.
Filed, my lord. Already filed.
Where is your affidavit?
My lord, yes.
And similar, we have already filed it 27 February 23.
My lord, kindly paragraph 11. 10 and 11 of this, my lord.
And I have
Plea.
already filed it.
Page number 4. Specific, my lord. Paragraph 11.
Yes.
Now here, my lord, before this honorable court, my lord, this bylaw is not being challenged also by
We
my
did
lord.
not go into that because they directed to file submit a revised sanction plan. No plan was submitted. So on the basis of that, we can proceed.
So regarding my client, my lord, I have.
With regard to respondent number
9, my lord, I am not. That your lordship can. I mean, 9 and 5. দশের হয় আমি করে দিচ্ছি
This public interest litigation has been filed, praying for direction upon the Howrah Jilla Parishad to demolish the unauthorized construction put up by the 9th and 10th respondent to this petition. First up, the learned advocate representing the petitioner draws the attention of the court to the order passed by the Howrah Jilla, to the order passed by the district engineer, Howrah Jilla Parishad, wherefrom it appears that the assistant engineer of the concerned Jilla Parishad during the course of inspection at the site found that the ninth respondent, that is Sheikh Ghulam Mohiuddin, already completed one G+2 storied building structure without any sanction plan from the Howrah Jilla Parishad. First up, it was further noted that the property was not demarcated with boundary wall or with any pillar. An affidavit in opposition has been filed by the it further appears from the said order that the Jilla Parishad granted an opportunity to the 9th respondent to submit a revised plan showing the structure as still now upon the said property. First up, though it is not in dispute that the virus of the provisions of the bylaws allowing the submission of a revised plan is has been challenged in a writ petition, and the same is pending. This court need not go into that aspect, as it appears from the affidavit in opposition filed by the concerned Jilla Parishad that no such revised plan has been submitted by the 9th respondent. First up, in view thereof, since the construction was put up without any sanction plan and the direction of the Howrah Jilla Parishad was not complied with by the 9th respondent, we direct the district engineer. The district engineer. You have not made the district engineer as a party. The district engineer, Howrah Jilla Parishad, being the added respondent number 11 to this writ petition, to immediately take steps against the construction, against the unauthorized construction put up by the 9th respondent. Within a period of 4 weeks from the date of receipt of a server copy of this order, insofar as the alleged construction put up by the 10th respondent is concerned, the the Jila Parishad will be free to take steps in accordance with law in case it is found that the same is an unauthorized.
That was not regularized subsequently. As per the bylaw, that was minor deviation.
The writ petition stands disposed of.
Gratefully.
Lord, kindly leave will be granted to my lord addition of
As prayed for by the learned advocate for the petitioner, একদম উপরে দেবেন। The district engineer Howrah Jila Parishad is added as a party respondent to this writ petition. First of the learned advocate on record is granted leave to amend the cost title of the writ petition. First up, since the Howrah Jila Parishad is represented by its learned advocate, there is no necessity to serve a copy of writ petition.
Today I have
upon
filed
the added respondent.
Today I have filed the opposition, my lord. Let it be kept on record, my lord. Annexing the plan and
affidavit in
revised plan.
opposition and the reply. They have filed a reply.
Yes, yes.
The affidavit in opposition filed by the 10th respondent and the reply thereto are taken on record.
Extremely grateful.